Hello, my name is Paul Smith, the Executive Director of the Utah Apartment Association. And today I want to remind you how serious the Apartment Association takes its role as the advocate for property owners and landlords. And in the last 2 years, we have ran 2 separate bills at the state legislature dealing with rentals and HOAs. And we've done that to strike a balance between those landlords that rent their units in HOAs and the communities and the people that live among them. So in 2014, over my shoulder, we passed a couple of regulations, and those were that HOAs could never ask for copies of the application and the credit report. It's a violation of federal law, the Federal Fair Credit Reporting Act, to give copies of sensitive information that has social security numbers to somebody that doesn't have authority. And we definitely should not be giving those to volunteer boards of directors or community managers of HOAs. They can ask for leases, they can ask for contact information on the renter who lives there, but they can never ask for an application or a background check. The second thing in 2014 that we did is we had some HOAs that wanted to pre-approve applicants. So they wanted you to take an applicant and then get their blessing before you made the decision, and that is absolutely inappropriate, and we have prohibited it. Imagine if the name of the applicant was Hernandez, or if it was a single mother, and somebody on the HOA board was racist or had something against children. That is a fair housing nightmare. Only the landlord should be the one determining whether the renter is qualified, and they should never discriminate on anything that is a violation of the Fair Housing Act, such as race, color, sex, country of origin, religion, disability, or familial status, meaning that there's children under the age of 18. Now, in 2015, we ran a follow-up bill to fix a couple of issues that we tried to fix the first time, but we weren't quite able to pin down with the Community Association Institute, the group that represents the HOAs. And I do want to give big kudos to them for negotiating with us and finding consensus and compromise on both of these issues. But in 2015, over this shoulder, we came up with 2 new protections. Now, first I need to tell you that many HOAs don't like rentals. And so they have come up with policies to discriminate against those landlords, in many cases charging much higher fees to the landlord. In some cases, $500, $600 extra a year. In some cases, $50 higher monthly fees. In some cases, requiring deposits or move-in, move-out fees. Anytime a tenant moved in, moved out, a big fee of $500. State law now prohibits that. You are not allowed to charge as an HOA any fee different to a landlord or a renter than you do to an occupant. So if you charge anybody that moves in and out a fee, you can charge that to everybody, but you can't just charge it to renters or to landlords. And then last, we were experiencing many HOAs that blatantly discriminated against renters by making rule restrictions on renters. One common one is that occupants could have pets, but renters couldn't. Occupants could use the pool and tennis courts and community areas, but renters couldn't. Those rules are discriminatory, they were wrong, and they are now prohibited under state law. So we have a very good compromise now where HOAs can have rules, they can have rental restrictions, they can ask for copies of leases, they can ask for renters' contact information, but they can never have higher fees or discriminatory rules against renters or landlords. Thank you.